Okay, ladies and gentlemen, welcome to Crosley Studio One. We are getting close to the end of the year, so we're in the Supreme Court. What I'm going to suggest is kind of open up two windows. Number one, to watch this. Number two, have the Google Slides for the Supreme Court and Judiciary out, and you can kind of follow along because There's a couple of slides there. I've got some uh, uh, visuals that help explain, and I'm going to reference them. All right, so let's get started. If you're looking at first slide, Supreme Court and Judiciary, you see there a quote from Justice Robert Jackson. Basically says, "We are not final because we are infallible. Rather, we are infallible because we are final." What does that mean? Well, first off, what the heck does infallible mean? It means perfect. So basically saying is we're not final because we're perfect. We're perfect because we're final. And what does that mean? Well, you know, it's the perfect decision. That's why it's final. Okay? Where else are you going to go? There's no other court after the Supreme Court. There's no world court to go to. Whatever the Supreme Court decides, that becomes the law of the land. All right? Skipping through here, looking at slide 3, you're looking at the structure of the federal court system. It's a triangle. At the base, where the most of them are the district courts, appeals courts, and then one Supreme Court. Now, we're going to work our way up here just a little bit. At the very base, most of it is the district courts. These are the trial courts. There's witnesses, there's cross-examination, objections. Okay? Just like what you see on Law and Order. Boom, boom. All right? That's the trial court. There's state trial courts and federal trial courts. We're talking about federal right now. So that's where your case will begin. If something goes wrong, you can go to the appeals court, the next level up. They will only hear the case if there was a problem in the district case. So let's say, for example, you're on trial. You've got a federal criminal trial. And you want to call some witnesses. And the court will not let you. You're going to argue that your rights were violated, your Sixth Amendment rights. And, you will appeal. You'll go to the appeals court. They will not retry the whole case. All they're doing is listening to that issue. All right? Why should you have been able to call witnesses? Why shouldn't you have been able to call witnesses? And here's the thing. That district trial case may take a couple of days, hours of testimony, maybe a week or two, whatever. Your appellate case, 30 minutes. The plaintiff's attorney gets 15 minutes. The defendant's attorney gets 15 minutes. And they argue why you should have been allowed to call or why you shouldn't have been allowed. All right. If you don't like the decision at that point, their decision will come out. You could appeal to the Supreme Court. Okay? And they're the court of last resort, so to speak. If you get there, whatever they decide, if they decide to hear your case, their decision is going to be final. If they don't decide to hear the case is done. That's the end. Now, all right, very simply put, looking at slide number 4, you see the state of Ohio line going through the middle. So it divides it into the northern and southern districts. And then you see 4 in northern Ohio: Toledo, Cleveland, Akron, Canton, and then southern Columbus, Dayton, and Cincinnati. And so those are the trial courts. There's one here in Toledo. There's one downtown, actually right across the street from the Juvenile Justice Center. So that's the federal court. All right. So Toledo would be the district for the northern western district court for the state of Ohio. It's a little complicated, but that's how it goes. All right. Then if you go to 5, slide 5, you see the 12 appellate districts. Now it says you only see 11. Number 12 is actually Washington, D.C. And so each district is made up of different states and all of their district courts. So if you look at Michigan, if you kind of zoom in, you'll see Michigan's got an eastern and western, Ohio northern and southern, Kentucky, I think it's northern and southern, and then Tennessee, eastern and western. All right. So all of those states make up the Sixth Circuit. And it used to be that a Supreme Court justice would ride the circuit back in the old days when 13 colonies could really do it. All right. So they hear that's the appellate. So the district or the appellate court for the Sixth Circuit is located in Cincinnati. Now you look at the Ninth Circuit. That's a huge one. That one is in San Francisco. So if you're in Hawaii, your attorney has to fly all the way to San Francisco to argue your case. It means money, and we'll talk about that. All right. So you've got that. Now, kind of moving on in slide-wise, some of the basics. There's 9 justices currently. Congress can expand. This is one of their sprinkle powers, sprinkled throughout the Constitution. Remember, not all power is in Article 1, Section 8, Clauses 1 through 17. You see some in Article 2, where the president gets to choose his nominee, but the Senate has to approve it. The Supreme Court, approve and ratify, that thing, appoint and ratify. And then, but they also can expand the Supreme Court's appellate jurisdiction, and they can create lower courts. So the Constitution really only created one court, and that was the Supreme Court. The appellate court and the district courts right here, 2 and 3, the lower levels of the pyramid, they were created by Congress because that's one of their powers. All right? And their main job is to interpret the Constitution. Now, these justices will serve for life. Why? Why don't we elect them? They make crazy decisions. Well, the thinking behind this is that if a judge doesn't have to worry about worrying about re-election, they will make the proper decision, not the popular one. For example, Roe versus Wade in the 70s legalized abortion. So, if a justice had to worry about getting elected, they may make the popular decision and rule against abortion where they, constitutionally found a right to privacy and they ruled for abortion. Okay? We're not here to discuss abortion or argue it, but I'm just kind of showing you how this works. All right? Now, they have the courts, all the federal courts except the district court. So appellate and Supreme Court. There's 2 types of jurisdiction, what cases they can hear. There's what's called original jurisdiction. That means they can hear the case first. And then there's appellate jurisdiction, where it's on appeal. Okay? There's already been a decision. Somebody doesn't like the decision. All right? So, now the Constitution, again, for the federal courts, lays out jurisdictions. So, for example, the Supreme Court has a very small, limited, very narrow original jurisdiction, what cases they can hear first. And that would be involving a suit between states, an ambassador, government official, something along those lines. Very small. Appellate jurisdiction, appeals, is wide open. Okay? That's why, Congress has that power. All right? And give you another example of jurisdiction. A federal trial court or district court does not have jurisdiction over a divorce. That's a state jurisdiction. Okay? So how do we know? Well, the Constitution says, basically, a federal question. So you're involving a federal law, a law passed by Congress. Divorce laws are passed by the state. Kind of see there? All right. And a lot of times if there's a rights, civil rights, voting, race, something along those lines, that then the federal courts will get involved as well. Now, the case will start in the federal district court and work its way up. It'll take years. All right. Now, how do you get to the ultimate goal of the Supreme Court? Well, first off, the Supreme Court gets to hear what cases they want to hear. Okay? And these cases don't affect how the law is written, how it's enforced. It's generally different stuff. It's interpreting what's already there. Okay? So, but to get to the Supreme Court, you've got to get what's called a writ of certiorari, certified to the Supreme Court. How do you get one of those? Well, you write your petition and you submit it to the court, and they look at every single petition. Somebody in the Supreme Court, whether it be a justice, a clerk, because all of the justices have what are called clerks. Sorry, my dog's barking about something. And these are these are lawyers from top schools, Harvard, Yale, Michigan, Stanford, top law schools. And they graduated in the top 5 out of those classes. So these guys are really, really smart. And they hear these cases, or they read these petitions. And they present them to the justices. Hey, this is a good one. This is a stinker, but if you want to read it, go for it. Now, the justices get together, and they will argue for their case. Hey, this is why we should hear it. These issues are involved. And if you can get 4 justices, 1, 2, 3, 4, to agree to hear it, you're going to hear it, get your case. All right? So, it doesn't guarantee that you're going to win. It just means you're going to get hurt. Because one of those 4 may change their mind when they hear the facts. But, you get your case, you might be able to get 2 more, and you got win. All right? So what are they looking for? First off, they're looking for conflicting decisions from the different circuits. Looking back at slide 5 with the circuits, all 12 of them, I'll give you an example. For example, the 9th Circuit said, hey, same-sex marriage is okay. All of the states in same-sex marriage in this district will recognize same-sex marriage. 6th Circuit, Michigan, Ohio, Kentucky, Indiana, that appellate circuit said no. So we've got a conflict. And the Supreme Court and the Constitution likes uniformity. So they'll look for that. They will also look to see if the state is involved in some sort of rights or constitutional issue. All right? Now, the court gets about 7,000 petitions. Only 100 will get a case. Okay? 100. Set 100 out of 7,000. That's 1 out of 70. Okay? Very slight odds. Now, the costs are high. $300 just to file. Now, that's not bad. Here in the state of Ohio, to file a case, you're looking at about $350. Okay? But you've got to make 40 copies of your petition. You've got attorney's fees. When the attorney writes up your petition, he just doesn't say, well, this is why. He goes and looks up all these court cases, everything. That takes hours. Just to give you an idea, I wrote an objection or a motion one time, and it took me about 5 hours, 6 hours of research and reading the cases and writing it to come up with the motion. And now you figure at $300 an hour, that is a big cost. Now, you could apply what's called informa pauperis, meaning you're broke, you're a pauper, you have no money. This is what Gideon versus Wainwright did. He was in prison. He said, I don't have any money. But they took his case anyways. And we've talked about Gideon versus Wainwright. 6th Amendment, write to an attorney where you might serve over a year. Okay? Or you might get lucky enough that you get a interest group to organize your case. For example, it says there in the notes, Heller versus DC. Okay? That was actually organized by the NRA, the National Rifle Association, because Washington, D.C. had a law that said you weren't allowed to own handguns in the city of Washington, D.C., and if you owned a shotgun or a rifle, it either had to be disassembled or had a trigger lock on it. Which, what's the point of having a gun for home defense if it's got all of that on it? All right. Now, arguing the case. Again, you're thinking Supreme Court, huge importance. They'll take their time. They do, but you only get an hour. Again, you're only arguing specific issues. They're not rehearing the case. All right? So one side gets a half an hour, the other side gets a half an hour. Boom, you're done. Very rarely do they go beyond that. All right? So you've made your arguments. Now what? Well, they got to decide the case. Well, every Friday they will meet and discuss the case. And they'll argue in order of seniority, youngest to oldest, if I remember right. And then they'll vote in reverse order. Okay? So they come to a decision. There's really 3 types of decisions. There's a per curiam. Short, unsigned, means by the court. Okay? We don't have to have a hearing on it, so here's the decision. And again, whatever the court decides, that is the rule. There's the majority opinion. This is the winning opinion. Minimum 5 agree with this. Whatever they decide is the law of the land. Okay? Maybe declaring a law unconstitutional. Their interpretation is the law of the land. Okay? This is the final decision. Then there's the concurring opinion. All right? They agree with the majority, but sometimes for a different reason. They use different logic to come up with the same thing. But they are on the winning side. And then finally, the dissent. They disagree. This is the losing side. All right? You still have, if you ever go to law school, you'll have to read that as well, because sometimes that's more important than the actual decision itself. Moving through here, there's what's called an amicus curiae brief, a friend of the court. So, gunman in that Heller versus DC, gun manufacturers would have filed these and said, hey, this is why, we think you should rule this way. It does have an influence. Okay? Now, they do have a role in public policy, how laws are enforced or what laws may be struck down. Now, remember, they may declare an action or a law unconstitutional, not consistent with the Constitution. So when it's declared unconstitutional, the law is null and void, has zero effect. And it's part of the checks and balances system. Now, how do you become a judge, Supreme Court justice? Well, first off, every lawyer is considered qualified. So theoretically, I could be a Supreme Court justice. All right? Because I'm a lawyer, I am considered qualified. So the president would appoint me, choose me. Hey, Mr. Crosley, I want you to be a judge. But again, I have to be approved by the Supreme Court. One of those sprinkle powers. All right? Keep that in mind. Sprinkle powers. Now, okay, I'm kind of flipping through my notes here. What I wanted to cover with you guys. Now, you guys don't have to really worry too much about slide 16. Okay, 18 through 25. Okay, that's the selecting judges. And then 27, really, the only thing that a judge has to worry about is getting impeached. But again, you've got your job for life as long as you are on good behavior. All right? If you're on good behavior, just because they don't like your decisions, they can't remove you. They can't dock your pay. They can't change your pay because they don't like your decisions. All right? So there we go, ladies and gentlemen. Watch this. Take some notes. I'm going to be sending out the Google form. Read through it. Use your notes. Read through the slides, and be good to go. All right? See you again.